Yeah, a very good morning to our German audience and a good afternoon to our audience in Australia, France, India, and Singapore. Welcome to you all to today's webinar, and I'm very happy that so many of you are joining us for this very interesting topic about intellectual property. My name is Cornelia Camacho, and I'm a consultant at the German-Australian Chamber of Industry and Commerce in Sydney. Our customer success team at the Chamber performs market entry consulting for German and Australian companies. We support companies in all aspects of how to enter the Australian market. For example, we prepare market studies and brief market analysis. We assist in finding suitable business partners for you through targeted business partner referrals using our network. And we act as a local business presence for companies, for you, with an Australian address, a telephone number, and telephone service in the name of your company. And of course, we assist with company startups and incorporations. Today's webinar is one of 4 market entry webinars which we perform during the year. Just recently, we had one about immigration, and today we want to talk about intellectual property, managing IP risk. This webinar provides a depth coverage of all aspects of intellectual property, including risks, rights, management and enforcement of IP. And I guess every successful intellectual property had one day a start when someone had an idea or a problem to solve, small or big. And sometimes these ideas are coming while you are under the shower or while you are going for a walk. It is everywhere that the start could have just happened for a really good product or idea. And understanding the different types of intellectual property is an important knowledge. Patents, trademarks, copyrights, and trade secrets are valuable assets of your company, and understanding how they work and how they are created is critical to knowing how to protect them. Examples for intellectual property could be, first thing what you probably think is patents, but also domain names or industrial designs. And intellectual property protection is critical to fostering innovation. Without protection of ideas, business and individuals would not reap the full benefits of their inventions and would focus less on research and development. Today's presenter is Olaf Kretschmer. Olaf Kretschmer is the CEO of One IP International Pty Limited here in Australia. He is advising clients in intellectual property matters for more than 20 years. Olaf is admitted as attorney at law in Germany, accredited trademark attorney with the European Intellectual Property Office EUIPO in Alicante, Spain, and Australian registered foreign lawyer in New South Wales. His practice covers all aspects of international trademark, product design, copyright, media law, and competition law. He provides strategic advice on the development, establishment, and management of cross-border trademark, patent, copyright, and registered design portfolios in a broad range of industries, including engineering, retail, strategic consulting, medical, food and beverage, aviation, and technology. Before Olaf will start with his presentation, I would like to briefly outline the flow of the webinar. We will start with a 35-minute presentation by Olaf Kretschmer, and then we will follow with Q&A sessions, where you have the chance to ask your question and hopefully get the answer straight away to your question. Those ones which those questions which we can't answer during our webinar time, we are happy for you to send them off to either Olaf Kretschmer or to myself. And Sonja, I would like you to put into the chat the email addresses so that the audience can find immediately the email address to send off any further questions. For your information, the webinar is also recorded, and we will be happy to make the presentation recording available to all participants afterwards. Give us a day or so. And there is no need now to write everything down. Please relax, sit back and join the presentation. I would also like to point out that all information shared is of general nature and does not constitute individual legal advice. And with that, I hand over to Olaf Kretschmer. Olaf, the floor is all yours.
Thank you very much, Cornelia, for this beautiful introduction. I will start sharing my screen now. Just a sec. Can you see my screen? Everything's working, so we can start this presentation about managing intellectual property risk. Again, Cornelia, thank you very much for the beautiful introduction about my person and what our global intellectual property legal services provider is providing to clients, small or large. Everyone in business needs to have a look at intellectual property at large and needs to make informed decisions. And for this, it's required to have a little bit of background knowledge. You don't need to have a deep understanding of it. After all, it's for the experts to decide what or what not to do. But in general, you should be in command of what is there, which of the intangible assets that there are being called intellectual property are for you. And this is very much different for every industry. I will come to that in a second. This webinar is about what you will learn today is about intellectual property. What is it at all? Like, what does it mean? Like real property, yes, it's a house, it's buildings, it's things that you can touch. What does intellectual property mean? Is it knowledge at large, or what is it? So we will talk about this. We'll also tell you how IP affects your everyday business decisions. Why is it even important? Yeah, I can't see it, I can't touch it, I can't take it under my arm. However, the intangible assets, that's what they're called, because they're not real, like you can't see it. It's just a right. The intangible assets are in many cases even more important than tangible assets. Think of the Apple brand. Like Apple is now one of the most valuable, if not the most valuable brand in the world. And it's most likely much more of much more worth than the tangible assets the company possesses. So this is a perfect example of how it all started small in the 80s, and the business owners grew it to an extent where they're absolutely famous. Everyone is mad about their products, wants to have it. That brings competitors to the plan who wants to participate in the success and trying to find a way to use the good reputation of this company. But obviously Apple was clever and has protected the IP, and therefore it is their little treasure. You can't see it, but you know it's there and it's protected. So we will talk about how you and your business are affected by IP. How does it apply to you? And then the next question, of course, how do you get it? How do you obtain IP rights? Is it through registration? Is it through just creating things? How is it done? We will clarify this. When you have it, when you put it in place, you have your perfectly designed IP portfolio in several jurisdictions across the globe. How do you make sure that no one is piggybacking on your success? Whereas like someone is using a similar name, is using a similar invention, is trying to use your knowledge, how do you stop them? How do you enforce your IP rights? First of all, but we will have clarified that much before we're talking about enforcement. Why is an IP portfolio even important? So it's not enough to just register one trademark or making sure the copyright cannot be infringed. If you're an internationally operating company, you should have a portfolio of IP rights that you can access and evaluate at any point in time, and that you are in command, knowing in which jurisdictions across the globe is your brand registered, is your invention covered. This is what an IP portfolio is all about, and we will talk about that in a minute. We are often asked the question like, is it worth the money investing? After all, intellectual property is a lot about investing money before you can even see the success. Look at the Apple people again. They have, like, probably in the 80s, everyone laughed about them and their funny logo with a bite off in an apple, some computer geeks fiddling around with some software. And here we are in the year 2022, and it's the most valuable brand. So you can clearly see that registering that logo of Apple, which is absolutely famous now, and several other software patents, has well and truly paid off, because they can now enjoy the success all themselves without having to make sacrifices. And so others would not be, especially competitors, they would not be able to enjoy the success of Apple. So everything was done right by Apple at the time, because they said, yes, it is an investment, but better safe than sorry. So we want to know we are in control. It's actually ours. And with the registration, let's say a trademark that is registered, I will come to that in a moment, is increasing in value. So an unregistered Apple brand would not be worth much, because everyone knew they could be using it, they could be infringing it without any for them, without any thing that they would have to be afraid of, because it's not protected. So Apple would not be able to enforce it. That's why. So one thing I want to say about this point, cost balance, value of proper protection, is it comes down to this tagline, better safe than sorry. So you don't want to find out in 5 years' time that your journey was a huge success, and someone else says thank you about it to it, and simply because you refuse to build door locks into your house, your neighbor walks in, sits in your chair, watches your TV and eats from your fridge, all lawfully, because it's not protected, so it's not illegal to use your stuff. And I must say, a IP portfolio with registered trademarks, registered designs, patents, and whatnot is worth very much more when you sell the company, because the buyer knows it's protected. So you would get something out of this deal if it's not protected, but you get much more if the buyer knows it's protected. So long story short, at least we're talking about the aspect of how do you involve third parties when they are helping you creating something, or you're creating work for other people that instructed you to do so, who owns the rights. And I make sure that we have answers to all of these questions after this webinar, and I will not read out all of the screens that you will see. after this webinar, the presentation is shared, so you can read it yourself. I will more focus on telling you the story behind it, or asking a few. You ask a few more questions, and I give you answers to this. Just quickly, managing IP risk means that you need to know what IP is. In general, IP comprises of trademark, patent, copyright, registered industrial design. Then there are also plant breeders' rights if you're a breeder and you create new crops and stuff, or you have circuit layouts if you design microchips. That is also an aspect of intellectual property. However, they don't apply to many businesses, and they're very unique. I just wanted to mention them here. The main IP aspects are trademarks, patent, copyright, and registered industrial designs. There are also plant breeders' rights and the goodwill of the company at large. So if you have any trade secrets, they're also intellectual property. Trade secrets, as the name suggests, should be a secret, so you wouldn't tell anyone. If you tell it to some people that you need to involve in your work, make sure they are signing a non-disclosure agreement. That's the best way to keep the secret a secret, because if they sign it and they make it public, they're in breach of contract and they are liable for damages and so forth. So a trademark, what does it protect? It protects the name. Here on the Coke bottle, it's illustrated. On one item, you can see several IP rights. So the name Coca-Cola and obviously the drawing of that wave and the red color, they are protected as a trademark. A trademark is a badge of origin that is registered for a certain person, so that certain person or company gets a monopoly to it. So no one must use the word Coke, Cokie, Coco. Everything that sounds similar, looks similar, has a similar meaning. Why? Because it could create likelihood of confusion. After all, if I use on my bottles a pink version of that wave, printed wave, and call it Cokie with double E at the end instead of Coke, one would at least think I'm a spin-off of Coca-Cola, and therefore the relevant public, so the everyday person, everyone drinks cola, the relevant public is the everyday person, would think I am associated with Coca-Cola, or actually I am Coca-Cola, which I'm not. But therefore I could have huge success, because all of a sudden everyone thinks it's a new product, they're buying it off me. In fact, I'm riding the wave of Coca-Cola, who are famous for it. That's why you can register the word Coke and the label as a trademark, so no one else must use it, and also not create any likelihood for confusion by using something similar. The patent would apply to anything that solves a technical problem. So an invention, it could be a machine, it could be software, it could be a process, something that solves a technical problem and is new. So if let's say an algorithm for the Google search is there, and you slightly change it and want to patent it as a software, it's not new. Yes, it's an invention. Yes, it solves a technical problem, but it's not new anymore. Or let's say a certain machine that produces, that puts the caps on the bottles of Coca-Cola. If that technology already exists, you need to create it in a way that it's very much different, even though it would solve the same technical problem. But then if you do it in a different way, your invention could be very well patentable. The design is another aspect of the product that a company is selling. It protects the registered design, protects the shape, the unique shape. And here I think of the Coke bottle, that screw-like bottle. There's no other bottle in the market with this kind of shape. Without the label, everyone knows immediately, yeah, it's Coca-Cola. And that's why a bottle of that shape can be registered as a product design, industrial design, and no one is allowed to use a similar product design. Or think of the iPhone. Without seeing the Apple sign on it, everyone would know, oh, it's an iPhone, simply because of the shape. And they have protected it. No one can have a similar product that has an overall appearance like that Coke bottle or the Apple, the iPhone, for instance. Copyright applies mostly to every outcome of a creative process. That might be a book, that might be photographs, illustrations, composing, sound, whatever you can imagine is the outcome of a creative process is very much likely protectable under copyright. I come to that in a second, where copyright is given for photographs or texts, for instance. Here in that example for the Coke bottle, it would be a photograph of the Coke bottle that I take, even though I'm not Coca-Cola, but if I'm a photojournalist and I take that photograph of that Coke bottle and use it for my article in a newspaper or in a magazine, this is actually not an infringement of Coca-Cola's rights, because I'm doing it as to fulfill my work as a journalist to inform people. That's all right. But on the other hand, no one can take away the photograph that I took of that bottle, because I am the photographer, and so I have the copyright on that picture. This is just to illustrate what different IP rights do exist and what they are protecting. The copyright is protecting the outcome of a creative process. The trademark is protecting the badge of origin against confusion in the marketplace. The patent is protecting the process that solves a technical problem, and the design is protecting the overall appearance of an industrial item. Yeah. What you need to keep in mind if you start a business, if you already have a business and haven't thought about it, the immediate thought needs to go to protect your business name, your company name, and domain name as trademarks. Domain name and other rights that you can protect as intellectual property. With regards to these, first come, first serve applies. So you need to be quick. If someone else was quicker and managed to file first, that means you're out. You missed out. This person will always prevail over you. First come, first serve. There are some countries that are first to use countries, for instance, the USA. For this, it's actually more important, for this country, it's more important to actually start using it, getting it out there, so that you can claim on this and this particular date, I started using it, and the use will prevail the filing date. But this differs from country to country. What you need to keep in mind when starting a business or running a business, do a business name or a trademark, a company name or a domain name search, and get onto it right away. Click, if it's available, register. Register that domain, register the company name, register the business name. This can lead to nasty blocking strategies of competitors that they do. They, for instance, if they manage to register the domain name where you have a registered trademark for instance, one IP is a registered word mark, one IP. A registered word mark for legal services. If someone were quicker with the domain one-ip.com.au, which is our domain, but if someone would have been quicker to register that, there's very little I can do about it, as long as they're not using the domain actively and have a website with legal services content on there. The actual use with content on a website would mean they're using the one IP as a trademark, as a badge of origin. As long as they're not using anything, they can say it's the mere address function of a URL, and I'm keeping it in my portfolio. And so I'm not using it as a trademark. Therefore, I'm not infringing your one IP mark. Thank you very much. So they can just keep it in their portfolio and keep sending me offers, whether or not I want to buy this, because I may need it. And that's why it's important to register domain names right away if you want to have one, or a company or business name. Company or business name, if you have a trademark, someone else registers this business name or domain company name, you still may be able to convince ASIC, the Australian Security and Investment Commission, to hand over this business name or company name to you. It's just a huge journey, because ASIC will say, okay, take this party to court, and with the judgment, you come to us and we give you the business name or company name. This is easily avoidable by you just jumping on the register with ASIC and registering it. Company name, business name, domain name, go for it, register. There is no second chance. Once you missed out, you missed out. And that's why it's often used for people, to blackmail businesses, because someone was quicker in registering. We start with a business name or a company name after you registered the domain name and the company or business name. You need to immediately look at the IP Australia trademark registration database, for two reasons. For the first reason is, again, is it available? If it is already registered in a similar or identical way, hands off, find another brand name. Tough luck, you missed out, but you're putting yourself in trouble should you want to try to use something that is already protected for someone else. That's the whole reason of a trademark registration, giving a monopoly to the registrant, to the person who then owns it. You don't, I need to say that clearly, you don't own your company name or business name without a trademark registration. An ASIC registration of a business name or company name is a mere administrative act telling the authority in Australia that you are operating under that name. If someone else has a trademark, this person owns this name. So the trademark owner can demand someone to take the name out of the internet, or not use it on any kind of paper, not use it in any way in the business world. If you don't have a registered trademark of your logo, your name, your sound, your design, whatever you use as a badge of origin to attract people. Let's say the people who see the Apple brand, they see the spite of logo, they see the word Apple, they associate a kind of quality with it, and that's why, because you either like or you hate Apple products. Those people who like it, they look for the name Apple and they look for the sign Apple. Wherever they see that, this is where we want to go. This is where we want to buy. This is the source of the products we want to use. And that's why it's so important, whatever company or business you're operating, that you have your brand name, your logo, your tagline, if you have a certain sound, think of the IBM sound, or any, what other unique sounds are out there. No sound comes to mind at the moment. I just think of the dum 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 sound that everyone knows. This is protected as a sound mark. Whatever is appealing to your future customers, protect it, make it yours. It's a little bit like you walk into the desert, find an oasis. If you want to build a house in that beautiful oasis, for God's sake, build a fence around it first, build the house and build door locks in. This is what a trademark registration will do for you. So when before you file a trademark application, you want to make sure you're not infringing existing rights. That's why you do a trademark search and you look for everything that is similar, or like the easy way to find something if you want to protect Red Rocket for a business. as a company name, business name, or product name. Then you do an identity search. If Red Rocket is already registered, then you need to find for yourself, is it in the area that I am in? Like if you are for instance, if you are a sporting articles producer and you call your tennis racket Red Rocket, for whatever reason you like it, you want to name it that way, and you want to protect the word Red Rocket, and there is already a company who is selling clothing and has registered the word Red Rocket as a word mark. Well, at first glance, it's not the same category. You're selling tennis rackets, they're selling clothing, but there is an identity in the wording. It sounds identical, it looks identical, so the spelling is identical, the connotation is identical. People will conceive it as Red Rocket. They see the word, they don't seem to try to find differences. They're rushing through things, and easily they will think this Red Rocket company is you, or vice versa. And because tennis rackets, for instance, and clothing are often sold on one point of sale, even you can end up in the same shelf where their product and your product are next to each other. No one, believe me, no one of the consumers will make a difference. They will think you are them, or vice versa. That's why you get the search result and then you evaluate, is it different enough? I make an example, what would be different enough? You are a tennis racket producer, and there is this clothing company, Red Rocket, and you are called Fat Pocket. So it doesn't make any sense. It's just an example, but it spells differently. It has a very different meaning, connotation. It sounds different. This is all these aspects are enough to avoid likelihood of confusion. So you can go ahead and register Fat Pocket. So that's the whole point of doing a trademark due diligence search. So you will know you're not running into trouble. So no one is sending you a letter of demand for alleged trademark infringement, and also the trademark offices around the globe. If you want to roll the brand out to several jurisdictions, they will not refuse your application because the examiner is looking for similarity. Is there a similar trademark already registered? If there is, they will refuse your application. You wasted your money on the application. What they also will be doing, and it's not possible for you to do, to register anything, any one of your competitors will need to describe their goods and services. So if you have a fruit business, you can't register the word apple for selling fruits, because otherwise no one of your competitors would be able to name their product an apple, because you have monopolized it for you. This is a silly example, but an extreme example that gives you an idea what you cannot do. So all these generic terms, beautiful sunrise, for instance, for a travel business, could be seen as descriptive because it describes of what the experience will be that people will have that signed up with that travel business. They will experience many beautiful sunrises. So there is a gray area where we're talking about pure descriptiveness, like the apple example. A piece of fruit is only named an apple. There is no other word for it. Therefore, it's purely descriptive, must be refused as a trademark. Red Rocket for a tennis racket is not descriptive at all. It's a perfectly distinctive mark. And a beautiful sunrise, well, one does not exactly know what it means. What does it stand for? Which goods and services are sold? So this is a bit ambiguous. Some examiner will say it's purely descriptive because of the experience that's encountered. Other examiners will not have a clue and will let you through. This is somewhere in between, but there is a hurdle that you have to take in order to register your trademark to overcome the likelihood of confusion and alleged descriptiveness. So trademark filing, one really good thing for someone who wants to expand the brand to various jurisdictions. You start with a filing in your home country. It's called priority filing. And what it does for you, if you if you file a trademark in Australia, it automatically blocks everyone in the Madrid Agreement or Madrid Protocol, which is the international treaty of several countries who agreed to provide the same sort of IP protection standards to all of its member countries. It blocks everyone from registering a similar or identical mark, even though they are in another country. Let's say, so you file in Australia, the Red Rocket example that we used. No one in the and then in the US, someone files Red Rocket also for tennis rackets 4 months later, which is still in the 6-month priority filing period. And then 5 months or 6 months later, so later than this person in the US, you file your Red Rocket mark. So it looks like, oh, this person was first, so I missed out. But because you can rely on your priority filing date that you have from Australia, which was 4 or 5 months earlier than this person that filed in the US, you can apply this to the US filing and you jump the queue. Even though this person in the US filed earlier in the US, you use your Australian filing date, and with this, you're certainly earlier than the US filing. This means filing in your home country gives you effectively 6 months time to work out which other jurisdictions do I roll out my brand. Does it make sense to register, to go to the Chinese market? If you don't see a market there, don't register. If you don't need to go to Europe, don't register. It would be a waste of money to register a trademark just as a placeholder, because you have 6 months time. You must decide where to lodge within the first six months. Opposition can occur, opposition and revocation can occur after you filed your trademark. The competitor might want to oppose marks. This is, in short, it's not going to happen if you have done proper trademark search. There is also a non-use proceeding. If you're not using your mark within the first 5 years after filing, it can be taken away from you because the law doesn't want you to block the register for good. We come to a life cycle of IP. This is very interesting because at the first part of an IP portfolio, you need to have a strategy. So you really need to work out, this is my product, this is my brand name, this is my logo, I have it all. Which markets do I want to approach now? Which do I want to approach within the next 6 months, within the next year, within the next 2 years? Where do you see yourself in 5 years? This kind of thing. But I assume you will have that anyway. With that strategy, you don't have to file everything at once to protect your product in all jurisdictions immediately. As I just said, you use the Australian filing date and use the priority filing date to roll out to other jurisdictions within the first 6 months. So you have the strategy of your markets, you identify which are your products, which names, which taglines, which sounds, what is distinctive, what do you want to make yours. You attend to the protection. Once you obtained protection for all of your trademarks, all of your patents, all of your registered designs in all jurisdictions, let's say you have 3 brands, 3 inventions, and 5 product designs that you have managed to protect in Australia, New Zealand, USA, Canada, and Europe. Then you know you have the registration certificates. If you find a competitor who's copying you, you can enforce it, you can sue them for a cease and desist declaration. They must stop selling it and must stop using it. They need to give you information in relation to the extent of their use, how much money they made of it, and then you're entitled to an account of profit. Or if you can prove a loss, you can get this loss back from them. You can recuperate the money you lost because they used it, if you are able to demonstrate the loss and the causal connection between their use and your loss. which is sometimes hard. That's why an account of profit is the best in terms of damages. They just have to hand over the money they made with your brand. After all, monetizing your IP is about creating licenses. If someone is keen to use your brand because they like it so much, you can create license agreement. They pay you an annual fee and allow them to use your brand. This is what monetizing is all about, and it's part of the commercialization strategy. I briefly spoke about patents. We have lots of inquiries with people saying, yeah, I want to patent my idea. This is sort of, it's the broad placeholder of protect what my idea is. Many of the ideas never come to life. The mind is free. There's nothing to protect as long as it's just an idea. Your idea needs to materialize. It needs to be a drawing. It needs to be a first like model, mock-up version, something that one can see and touch, something that is more than your thought. If that's the case, and you have a beautiful drawing or a first model, one can see, does it solve a technical problem, and is it new, and is it inventive? So is it something that not everyone would immediately realize? If that's the case, one does a patent search in the relevant jurisdiction, finds out if it's available, and then you jump on the registration and do this immediately. Here are the things that can be patented. It's either a process, a machine, an article that's the outcome of that machine operating, or a composition of chemicals, which is most likely in pharmaceutical components. This is just a broad overview. There are many more. But don't forget, when we're talking about patent, it's always about newness and solving a technical problem. So here is the broad overview from the idea to making actually a profit. I will not talk about this at length because I'm signaled that we're running out of time. Again, like if anyone has a question to me, send it to AHK or send it to us directly. We are happy to schedule a one-on-one appointment with you and talk about it in much detail. The IP protection should be getting the whatever it is, patent registered design or trademark, getting it in your home country, in the home market, and then rolling it out through the World Intellectual Property Organization in Madrid. And you simply have to designate the jurisdictions where you want to see it protected, do a search whether it's available there. You should have it valued so we can put a price tag to what's the patent actually worth. And based on the value of the patent, you can work out what your license fees are. You can enter into coexistence agreements. You can sell your patent and then assign it to someone else. That's obviously subject to the price that you would negotiate with them. To the core idea of that webinar, IP risk, I can't stress it enough. First come, first served. You need to have a strategy. Not having a strategy, not knowing where you want to be in 5 years is the worst. You need to have a strategy, and based on the idea where you want to be in 5 years, you work out how to achieve it with the budget you have at hand. You need to be aware of trademark and IP oppositions in general, because your competitor will not like what you do. If you're a huge success, they want to have you down. By doing proper searches in the beginning, it's ensuring they can't stop you. After you have your IP registered, it's super important to have the monitoring in place. So you need to make sure that other people are not actually copying your products, that they are not applying for similar trademarks. If they do, you need to lodge an opposition and stop them from doing it, because in some cases, the Australian Trademark Office and other trademark offices around the world simply don't see the similarity, or they don't think it's too similar, but you think. If you want to do something about it, lodge an opposition and you can stop them from getting registered. Or if it already occurred, have a revocation action lodged, so their trademark is actually canceled again. There are several strategies that you can apply according to the move that your competitor is doing. Sometimes you need to be aware that you need, because you have, let's say, 26 brands in 50 or 70 different jurisdictions. It's unlikely that your brand name is available as a trademark registration in all of these jurisdictions. So this is how the coexistence of Burger King and Hungry Jack's came into place, because Burger King couldn't name themselves Burger King in Australia because someone had registered Hungry Jack's. So Hungry Jack's was a registered trademark, and so the US company had to make sure that they're not infringing. So they had to rebrand, but not in its entirety, just for the Australian market. And this is something you have to keep in mind. Sometimes this happens, no one enjoys it, but it's unlikely you can roll out your brand in 170 countries. Simply not. You can't, there's no second chance. If you need to cover other areas, let's say you're a sporting article brand, you need to cover other areas. Think about it first before you file, because if you come back 3 months later, you will have a later filing date. You need to lodge a new application for that. You can't go to the existing application and add another class, like covering other items as well. This first application needs to be perfect from the start. You need to be prepared that you're refused in some countries, allowed registration in other countries. You need to work around, if it hasn't worked in some countries, what can you still do so you are allowed to use your brand in that country? And it's most likely a coexistence agreement with an existing trademark owner. You enter into negotiations with them. There's a lot you can do, even if you think it's the end. It's not. It's only over when it's over. And I'm happy to discuss this with you in a one-on-one session. If you're experiencing one of these problems, there's almost always something you can do. Think about litigation funding and apply IP legal expertise at an early stage. If you don't have deep pockets available, you don't have the money to defend your IP rights in court, think about IP insurance that is now in place. So you can insure your business against any IP litigation matters. Ask insurance companies, and it's a really good idea to have an IP litigation insurance in place. You should also consider that only because you can read and write and you're experienced and you are 60 years of age and you have lots of business experience, should mean that you approach everything yourself, do everything yourself. It makes perfect sense to have an expert with expert knowledge that is part of your team. It doesn't mean you need to employ this person, but you have, it's a go-to expert where you ask for advice when you need it. It saves you time and money because you don't make mistakes that can't be fixed afterwards, or that would get you to overspending. Like the example in the beginning, when you think I want to roll out my 26 brands to 70 countries, you don't need to protect 26 trademarks in 70 countries. When you're using the priority filing date, you have half a year to work out where your markets are. This way you save massive amount of money. So it's good to look at that. You need to make sure that you have preventative actions that actually ensure that you're not running into any litigation scenario. The main thing is to have a strategy in place that prevents you from clashing with competitors. Either them infringing your mark, how do you show them, okay, you have no chance, so just leave it, or that you are running into an infringement scenario. There's no innocence that you can claim that will hold you accountable for it. So
Olaf, I'm just putting the hand up. If you could come to an end so that we still have some questions and answers.
So give me another 2 minutes. I will finalize.
Not a problem.
Okay, thank you for making me aware. The time is ticking off very quickly. So as I just said, you can see it in the presentation that you will be handed out, and then we can discuss your concerns in more detail. Who needs IP protection? Basically everyone who is doing business, from the mom working from the kitchen bench at home to the multi-billion-dollar company with several branches across the globe. As soon as you are using something in business, it is subject to IP protection, either an invention, a name, everything that I just illustrated. So IP is for everyone, unless you see, you think like, okay, I don't mind if someone is able to use what I build. So the answer to this question is very short. And so it is a twofold. It protects you from stepping into an infringement scenario because it's yours. You cannot infringe other people's rights, and it prevents others from using your goodwill. So it is shield and sword in one thing. A very unique asset, and it also increases your company's worth, because a buyer would see the IP portfolio protected, so they will pay much more if you sell them your company and everything associated with it. Innovative processes and everything that is subject to that is outcome of a creative process is IP and is worth protecting. Well, here you have a very distinctive summary of what can be subject to protection. What is, yeah, you can, I'm basically done with this presentation. The rest you can see from the presentation, and you can ask questions now. Or I'm happy to talk to each of you in person via Google Meet, where you can ask individual questions. It's just like too much to talk about. I could talk another 3 hours.
We can see that you are really enthusiastic about this topic, and I have to say there is so much knowledge what we can hear and see and what everyone has to consider. And therefore, thank you very, very much for your presentation, Olaf. And I want to encourage everyone now, if you have questions, please put them in our Q&A, not into the chat. And we are really happy if you write them quickly and we will go through. Now, Olaf, what would you say are the most common first mistakes what people are making when they start?
There are a lot. So we have a lot of people that inquiring with us first, like, what do I need to protect? We tell them, they never do, because they think, oh yeah, I never had a trademark for 5 years. It has all worked out. I most likely don't need it. And shortly thereafter, half a year later, they receive a letter of demand from a competitor saying you have a similar name. And they go, we should have done it. We really should have done it. So having, like, the worst is having all that knowledge, what exists, but not doing anything, because you would think, it will all work out. I take my chances. Yes, it could. It's like a life insurance. You don't want to find out later, once you're not doing really good, that you should have signed up for it and you should have protected yourself, but you haven't. Simply, I don't know, because you're lazy, too afraid, or whatever. All of the reasons you will find later are not good enough. There's no second chance. So either not informing yourself properly over what is there as IP, or even worse, knowing about it and not taking any action. Unless you say, okay, if my business is a huge success, I don't care if others using my stuff. Well, it may exist. I don't think any business owner will agree to this, but this is basically what I think their mindset is if they accept running a company without IP.
And Olaf, people are thinking, oh my God, there is a lot of money to invest. You were saying that in the beginning also, that you need money to invest into this intellectual property to protect it.
Yes.
And now somebody comes and starts to infringe actually your IP. So you have done the right thing, but now somebody is infringing. So now the question is, I don't have the money now actually to go after them, because I expect that now I have a big court case to fight. So how do you go across with something like that?
So this starts early. When you start a company, you ideally build a budget for defending whatever is thrown at you, like against everything that is thrown at you in business. Might it IP, might it be other, let's say you are dealing with a statement of claim lodged by former disgruntled employees or so. So there are some due diligence things that you need to keep in mind, not only IP is one of them. And so budget building is key. So don't spend everything you have when you start. Build a little budget and grow it every month. Like put back $1,000 a month, as little as $500 a month to that budget. Build it. Make sure that you ask some insurance companies about insuring your company, your business against IP infringement, especially when you have inventions with patents on it. You need to, okay, you have spent the money on patent protection. Now you need to be able to enforce it. But luckily you signed up for this insurance that covers your patent infringement case. Fantastic. So you have the protection in place and you have the infringement covered. So the least costly component of that, if we're talking about litigation, which is the worst that can happen because you were not prepared, and actual protection. Protection doesn't cost that much. Let's say you run a company. If you're a small company, you need to spend at least 50 to 60K a month. If you're a large company, you have a multi-million-dollar budget. That doesn't matter. When you start, spend something on setting this IP portfolio up. You can do it gradually, like per month. You start with the main invention, with the name, with everything that's there, just in Australia, which is not as expensive. And then over the next 6 months, you protect it in all countries there are that you need.
Protect, yeah.
And that within 6 months, you have the money spent on IP protection. That will never come back. You don't have to do it again. All you have to do in 10 years time for trademarks, in 5 years time for registered design, in also 10 years time for patents, you need to renew it. But the renewal are cheap as chips. Okay, you set it up once, you get it going. At the same time, you set up a relatively cheap annual fee for the IP insurance, and you're sorted. So you don't have to throw it in all at once.
All in one go.
Have a strategy, and we tell you, this is main part of our advice. We tell you how to stretch your budget so you can stretch it over 6 months or a year and have everything beautifully laid out.
Fantastic. We have another question here. Do Australia and New Zealand share common IP territory, for example, via a trans-Tasman arrangement?
So yes, indeed, there is a trans-Tasman agreement between Australia and New Zealand, and common principles in IP protection, IP infringement actually not only apply to infringements between Australia and New Zealand, actually apply to all World Intellectual Property Organization members, WIPO. There's the Madrid Protocol, there's the Madrid Agreement for trademarks, there is a global patent PCT agreement. All the member states have agreed to apply the same sort of standard of protection to its members, and that's why if you're covered in these countries, the same principles apply, and it's not inventing the wheel a second time every now and then.
One more question. If you are a German entity, for example, or any other entity, and you haven't got an entity here in Australia, and you think, okay, now I have this idea, and first of all, I will register a domain name with .com.au. Now, you will come quickly to the point that you can't do that. But if you have a trademark, are you good to go then to get this domain name?
Yes, you can.
Good. So that is the first step. Probably you have to have this trademark.
Get a trademark in the home, in your markets, in your. That's why I said, like, work on, have a strategy in place before you even start selling your goods or starting your services. Before you're opening your stall,
yeah,
you know where you want to be in a year's time, in 2 years, in 3 years, in 5 years.
Exactly. Olaf, I think we have come to the end of this webinar, and ladies and gentlemen, a very big thank you to our presenter. If you have any further questions, as we said, Olaf Kretschmer and his company are happy to take these questions on. Please email and make an arrangement for maybe an appointment and get all your questions answered.
There's actually a link at the very last page of the presentation that I have open now. Thank you. Where it says schedule a virtual appointment with Calendly. You can click on it and you select a date and time. Then it suits you. And we are on a Google Meet then. So talking to each other over the camera.
Fantastic. That is a really good opportunity. And I would also like to draw your attention to our newsletter, which we use to keep you informed about really interesting topics like we have heard today about intellectual property. Of course, we are also letting you know about any other events which we have either in person or of course, online during the whole year. And in this sense, we wish you a nice rest of a working day for the listeners in Germany and a pleasant end of the day for the participants in Australia. Hopefully you enjoyed our webinar, and we would be happy to welcome you again to one of our next webinars or events. Thank you very much and good night.
Thank you.